Speaker.
Charles Chevelle.
Thank you, Mr Speaker. Mr Speaker, as we've heard, the legislation bill arises out of two Law Commission reports, one dating from October 2008 and the other dating from May 2009. And it is clear, I think, that those reports set out a compelling case to update the law relating to the publication of New Zealand legislation. The original Act that is on the books at the moment dates back to 1920, and so given the changes that have occurred in our society and in this institution since then, it is, I think, timely to be having a look at those Law Commission reports and implementing their recommendations. And the Regulations Review Committee was very happy to be part of that process, to hear submissions on the legislation bill and to make some recommendations around how that bill could be improved. Sir, I want to just make a particular reference to some of the evidence that the Regulations Review Committee heard in respect of this bill. I want to note that we were privileged to be addressed in the committee by two former Chief Parliamentary Counsel, and I want to just pay tribute to each of them because they gave very careful and helpful evidence. The first person that I want to acknowledge in this regard is Walter Isles QC. Mr Isles reminded the committee that I, as chair of the committee, would probably believe everything that he had to say to the committee, given that his father founded the law firm in Gisborne that my father became a partner in 1959. Now, he's absolutely right. I did believe everything he had to say, but not for that reason. The other former Chief Parliamentary Counsel from whom we heard was the late George Tanner QC. And again, I want to place on record in the House my gratitude and the indebtedness of the committee for the evidence of Mr Tanner. Members will know that Mr Tanner passed away from an illness some short time ago, and it seems to me that this is an appropriate juncture for me at least, and I hope other members, to place on record our gratitude for the tremendous service that Mr Tanner gave the House, which he repeated in the evidence that he gave to the Select Committee, which directly led to the clarifications and improvements in the bill that we are considering and that which the Minister has indicated the Government will adopt. What are those changes? Well, I think it probably is worth mentioning a couple of them. Members will be familiar with the concept of legal privilege. That's the ability to communicate in absolute confidence with one's client. It's a necessary adjunct to the practice of law because if, as a legal advisor, it isn't possible to know that your communications with your client are utterly secure, then you can't possibly give free and frank advice. And one of the problems that we found with the original draft of the bill was that, oddly, Parliamentary Counsel didn't have any automatic legal professional privilege when they were advising ministers or members of Parliament in respect of Select Committee work or private members' bills. So we thought it was important to rectify that and to give Parliamentary Counsel the sort of protection that every other lawyer and legal advisor has in practice, the ability to ensure that their communications and advice to ministers, members of Parliament and others were utterly confidential and able never to be questioned in legal proceedings or otherwise. And that will be accomplished by new clause 58B3. Sir, one of the other changes was touched on by the Minister. That relates to the qualifications of Parliamentary Counsel. Members might be surprised to know that there's no provision in the statute book at the moment around the sort of minimum qualifications that we would expect from those who serve in the Parliamentary Council office. We've tried to rectify that by specifying that ordinarily Parliamentary Council will be New Zealand qualified practitioners. But again, members will know that we've expanded quite radically in recent times the categories of person who can so practice. We have, and the Commonwealth of Australia has, passed mutual recognition legislation, meaning that any person admitted in one of the states or territories of Australia may apply to become a legal practitioner in New Zealand, and they have the right to so apply, and it is automatic that it will be granted, and vice versa. I know that there are legally qualified members of the House who have applied and succeeded in being accredited to practice in Australian states. I'm one of them, accredited in New South Wales. That shows that the reality of our deepening Trans-Tasman relationship means that we can call on a wider pool of lawyers than we otherwise could have. And if we have a look at the way in which the Regulations Review Committee has recommended that the statute be amended, we've also looked to other common law jurisdictions. Why should we deprive ourselves of the ability to call on a Canadian lawyer, a lawyer qualified in the United States, a lawyer from Hong Kong, a lawyer from any of the other common law jurisdictions who might have deep administrative experience or deep law drafting experience, and who might well be able to lend that expertise to the New Zealand Parliamentary Council office. Under this legislation, that will be made, it'll be made clear that that's absolutely welcome in New Zealand. Sir, another important change is made by Clause 71A. In the State Sector Act, Section 77 of the legislation makes it very clear that provided a public servant is acting within powers and in good faith, then the public servant has no liability, the Crown incurs no liability for the acts taken by the public servant. It's a very important constitutional provision. It means that our public service can function more effectively without having to worry all the time about whether any piece of advice or policy implementation might give rise to litigation. There was no such provision in the statute book relating to Parliamentary Council, and so because Parliamentary Council aren't part of the core public service, we've had to provide for that, and that amendment has been added in Clause 71A. Finally, sir, there are some amendments to the definition of what sorts of instruments can be considered by the Regulations Review Committee and scrutinised on behalf of the House. We've changed the terminology in the original bill from legislative order to legislative instrument, recognising that it's not just orders in council that will now come to the Regulations Review Committee, but other types of delegated legislation for scrutiny as well. Sir, two other quick points before I finish. The Minister noted that the Law Commission recommended that provision be made for a select committee to be created to hear and deal with revision bills. That is, bills that are technical in nature, that don't need to take up the time of this House through 3 readings and a committee stage, but can be dealt with through an expedited procedure. I think that would make an enormous difference to the efficiency with which we do our work. I'm pleased to hear that the government intends to progress that through standing orders. I urge that it happen sooner rather than later, just from the point of view of being able to do our jobs better. Finally, sir, listeners and other members might be wondering about the reason for the delay in progressing this legislation. I said the Law Commission reports came from 2008 and 2009. The bill was introduced in 2010. It's only now being read a second time, despite the fact that it was reported back from the Regulations Review Committee last year. We were told in the estimates process by the Parliamentary Council Office that this was because the government intended to combine the legislation bill with the Regulatory Standards Bill. I made it very clear on behalf of the opposition that wouldn't be acceptable if a bipartisan approach to this legislation bill was being sought. The Minister abandoned that course of action. I'm very pleased to say that, having done that, I can now commend this bill to the House.
Call Katrina Shanks.
Thank you, Mr Speaker. It's my pleasure to take a call